you very often. I know that you are very familiar with this Article 47 of the Constitution, fair administrative action. But permit me to read it to you. Every person has the right to administrative action that is expeditious, efficient, lawful, reasonable, and procedurally fair. If a right or fundamental freedom of a person has been or is likely to be adversely affected by administrative action, and promote efficient administration. But the petitioner was not given any hearing at all, absolutely none. What I may point out to you, those very respectfully, I appeared before your brother, Mr. Justice Kamari, together in Malani here, Waiko, and Mr. Hart, and many other senior lawyers. Orders were made by the landed judge. Several orders were made by the landed judge. For Miguna Miguna to be produced before the court. The landed judge even took a very unusual step. He stayed with us in courtroom, in his chambers, up to about 8 o'clock at night, waiting for Mr. Miguna Petitioner to be brought to the court. He was not brought to the court at all. There was clear disobedience on the part of the authorities. There was clear contempt of the court on the part of the authorities not to obey the orders of the High Court at all. And finally, my Lord, we came to learn through corridors of information that Miguna had been rushed to the airport. Put on the KLM aircraft and sent to Canada. Clearly, my Lord, rules of natural justice were never complied. He was never given any hearing by anybody. The respondents acted in a very contemptuous manner. They demeaned the authority of a superior court. My Lord, you can see me in a different uniform. I'm having a yellow ribbon. I don't usually have a yellow ribbon when I'm appearing before you. It's because our able president of the Law Society made an ordered all of us administratively. But as a Law Society, we have to protest that the executive of this country is not obeying court orders at all. Well, if you read this one, which is well written with respect, it argues the case very well for this one. I do not have to say much, but to plead with you that you make an order suspending the orders that have been made so that Miguna Miguna can be returned to the country immediately as a citizen. To join his family, to join other Kenyans, and to participate in the legal proceedings pending before. Such an order or such orders will send a clear signal to those in authority that the orders of the courts remain supreme. It does not matter what your position is in the Kenyan society. You are under the law of this country. But there is an expression in the common law of England that judges are lions under the crown. In this country, it is different. Our judges are lions under the Constitution. We do not have a crown. What we have is the Constitution, which is supreme. And it is that Constitution that we are urging the Lordship respectfully to uphold. It is not for the self-ego of a judge at all. It's to ensure that the rule of law in the country prevails. A decent and civilized way of doing things prevails. My Lord, with those remarks, before I sit down and argue with you, make the orders. Delaying making such orders, my Lord, as my learned friend from the state appears to suggest, would be sending the wrong signals to everybody. We require promptness to restore law and order. We require promptness to restore the rule of law in the country. My Lord, my friend, Mr. Onyeko, has one or two things just to point out to him. When you were talking outside, I told him that you better point out this yourself. permission to say something at the most critical. It will not take much time.
Thank you, Senator. I'm going to be very brief, my lord, and just point out first what the case before you is about and what it's not about. The case before you is not about whether Miguna has Kenyan citizenship or he doesn't. That's not a determination for you to make. The case before you is about whether the treatment that Mr. Miguna underwent met the procedural safeguards of the Constitution, starting with Article 47, as pointed by Senior Counsel, the Fair Administrative Action Act of 2015, and other procedures within the Constitution, and more specifically, Article 48 on access to justice, and Article 50 sub Article 1, which is every person who has a dispute that can be decided by application of the law, then should have that dispute decided by an independent tribunal. Just to point out to you, under the Foreign Nationals and Immigration Act, Section 23 to be specific, it establishes a tribunal.
Section
23 of the Kenya Citizenship and Foreign Management Act. It establishes a tribunal. And beyond Section 23, that act establishes certain offices to administer the Kenya Citizenship and Immigration Act of 2011. Part of the mandate of that tribunal is to review the decisions of the director and the board. The decision that was taken purporting to take away the citizenship of Mr. Miguna, then under Section 43 and Section 33 of the Kenya Citizenship and Immigration Act, in terms of designating him as a prohibited immigrant, were decisions that were taken or should have been taken pursuant to both the Kenya Citizenship Foreign Management Act and the Kenya Citizenship and Immigration Act. Those are decisions that ought to have been taken through a stream which includes the director. Those decisions, as Council has pointed out, are subject to fair administrative action, and they're also subject to Article 50 sub Article 1. And just to illustrate, this is what happens on February 6th. The record before you shows that when Mr. Miguna was charged or was presented to Kajiado Law Court, he was designated a Kenyan. That's what the charge sheet says. So as at 12:30 on February 6th, 2018, the Kenyan government considered Mr. Miguna a Kenyan citizen. So what needs to happen between now moving from a Kenyan citizen to deporting? What needs to happen in law is there needs to be suspicion that he's in violation of the law. And that suspicion has to relate to citizenship violation. If there is suspicion, Article 47 says inform him so that he can come and clarify the suspicion. After the clarification, the director makes a determination to advise the minister. It's an adverse inference. So he's entitled to an Article 47 process of reasons and information. Then after that, before the minister makes his final determination, he's supposed to invite him to make representation, because they are all acting under quasi-judicial powers. None of that has been done, or none of that was done. There is a second layer, because that's just on the designation relating to citizenship. There is designation relating to prohibited immigrant under Section 33 that they allege. That process relates to a foreign national, not a citizen. So even assuming and giving them all the benefit of the doubt that the process of purporting to take away his citizenship had been procedurally done, they have to go through that process again in terms of suspicion, information, and disclosure and reasons before they can designate him a prohibited foreign national, because that's a second layer of determination. That was not done. But what is even more surprising, my Lord, is between 12:30 p.m., all those processes, and this is what the government would want to tell us, were completed. And before 11 a.m., in fact earlier, to be able to facilitate buying a ticket for him to leave the country. So, my Lord, we submit clearly, even from a prima facie level, the most basic element of procedural fairness was not met. Leave alone for a citizen, but even for a foreign national, which is required. So while we ask you to look at Article 47, and Council has addressed you on citizenship, in fact, the emphasis there is the minister has no powers, and they cannot locate any powers under the Immigration Act to take away citizenship, because that's something given by the Constitution. And it's also telling and important that the citizenship right is not even located within the Bill of Rights. It's located outside the Bill of Rights. So even in terms of limitation, you cannot develop your own limitation other than what is built in the actual provisions of citizenship in the Constitution, and none of those actually affects Mr. Miguna. So what we are asking you to do at this point, it's actually fairly straightforward. It's straightforward because the question before you is to look at, there were court orders, were those court orders followed? Mr. Miguna was to be produced so that he can go through a fair process, including a criminal process. He's not even able to do that. He's still entitled to that process. The charges are still with the Kajiado local. They've not been withdrawn. And even if there was an attempt to withdraw, he may want to oppose the withdrawal so that he can get an acquittal instead. He's entitled to that at the minimum. The second level, whether he's a citizen or not, he was entitled to procedural fairness. Very, very basic elements which were not met. Subject to any questions, I will leave it at that.
Before Mr. Mutinda says something,
Yes.
you have alluded a lot to the issue that was before justice.
Yes.
Was it concluded?
It's not. And I'll let Mr. Harvey address you because he's counsel of record on that.
My Lord, when we appeared before Justice Kimaro on the 6th of February, he said that the application that was before him was in the nature of an application for anticipatory bail. And he said he was closing the file insofar as he granted the unconditional release of the petitioner in this matter. The judge proceeded to say the right by the petitioner to sue for the violation of his rights not to be detained and upheld unlawfully in the court. And there is a ruling to that effect that we pursue it through a petition. So what is outstanding before the brother is only the issue of decreeing sentence on the Inspector General of Police together with the Director of Criminal Investigations, as regards the refusal to comply with that court order. But the removal of the petitioner from this jurisdiction is something that has already happened. It can only be addressed
Mr. Matenda?
in a substantive petition.
My Lord, as I indicated at the outset.
You were served yesterday.
Yes, we were served yesterday, my Lord.
At what time?
About 5 p.m.
5 p.m.
Yes, my Lord.
You were served a matter under urgency?
We were served with a motion.
Under urgency?
Which was a motion under certificate of urgency, my Lord. We were also served with the petition and together with a mention notice for mention of this matter today at 11 a.m.
Did you file some ground, polling ground at least, so that
We
the
did not
majority
file-
the court is going to hear?
My Lord, my understanding of this matter, and of course, given the documentation that we were given, and specifically the mention notice, was that the matter had come under certificate, no orders were issued, and that the court required the parties to appear before it today for directions. And that's
So
the
what
reason
do you
why-
want us to do? Are you ready to proceed today?
My Lord, I will not be ready to proceed today. Considering that, my Lord, I would require my clients, who are the first to seek respondents, to provide us with facts and instructions to respond to the application before you and the petition, my Lord. But since we are dealing with the application, let me say the application. My Lord, when you look at the orders that are being sought, my Lord, in the application, they are orders to suspend the declarations under Section 43 of the Citizenship Act, declaration under Section 33 of the Citizenship Act, and of course what was urged here was a return of the petitioner, my Lord. As to why he was taken out of the country, there are underlying facts, my Lord, that need to be brought to the court. What you've heard is the side, of course the petitioners have said their part, but also there is the part of the government that needs to be brought up. The court can consider justiciable manner. My Lord, when you hear the petitioner say there was violation of Article 47 rights, that's a factual question. It's a question of fact that requires to be demonstrated. They are saying we violated, but what is our position? Is it true that we violated Article 47 rights of the petitioner? Or is it that there was no procedural fairness at all? My Lord, I have looked at the entire petition, and inclusive of the entire petition, there is a declaration, the declaration that is sought to be challenged. It says the petitioner is not a citizen. My Lord, citizenship is a question of fact. They are saying he's a citizen, the minister is saying he's not. This is a question of fact that requires to be demonstrated to the court, so that the court can even consider the application. Basically, my Lord, without taking so much of your time, what we are saying is, give us time, my Lord. We file papers. We will abide by any directions of the court to respond as soon as possible so that you can determine the application that is before you.
Yes?
So with that, my Lord, my request for today is that you adjourn, give us an adjournment for today, allow us a limited period of time to file papers, because as what is coming out, these are factual questions that require to be rebutted by other facts. Even when you look at the orders that are being sought, they are like in the nature of final orders. They can't be orders that can issue at the interim stage or even at this stage expert. So, my Lord.
Which ones? They only say suspend.
Yes, suspend.
Suspend is a measure temporary.
Thank you, my Lord.
How do you understand suspend?
Suspend, and at the end of the day, you are also seeking to quash.
Yes, you suspend before you quash. You answer yourself, isn't it? Yes, Mutinda, I hear you. You want a limited period of time.
Yes, that is all I'm asking for, my Lord.
That is how much time?
Give us at least tomorrow, my Lord, and then you can tell us to come another day that we can be heard. At least
I give you tomorrow, and then I can tell you which other day to come. So when do you want to come?
My Lord, you can give us 3 days to respond to the...
Now you are shifting from 1 day.
At least 1 day to 3 days, my Lord. 1 day to 3 days. We will be ready to come.
How many days do you need, Mr. Mutinda?
My Lord, so that I can be able to conduct all these clients of mine. And of course, noting that there were other proceedings which is coming out here.
As he said,
Yes.
that was concluded insofar as this petition is concerned. That's why I asked him, so that we would not conduct parallel proceedings.
Yes, my Lord.
He said the issue as to his rights was concluded before that court.
That could be the case. I'm not very sure about it.
You must be aware than I am, because you are in the office that sometimes represent those people. So
Yes.
when do you want to come back here? You matter
Friday,
came under agency.
On Friday, my Lord.
So that means you require 2 days.
2 days, my Lord.
Friday is which day? It's which day?
Friday 16th.
16th. What time, you know? He requests for 2 days to respond. We can come back on Friday. What do you say to that?
We are opposing that. But what we are asking for prayers 2 and 3, suspend. You will then be at liberty to argue as much as you want. Nobody will stop them from arguing at all. But let us look at this matter in its proper perspective. It is a fact that court orders were not obeyed. There's nothing to argue about that. It is a fact that our client has lived in this country for 56 years. It's a fact that he is a citizen of this country. The constitutional provisions are very clear. It is a fact, as propounded by my friend Soiko, that procedural provisions relating to fairness were never complied. There's no factual issue to be clarified at all. All we have is law, which is very clear in favor of Mr. Miguna. And I urge you respectfully that you give us prayers 2 and 3.
Dr. Lino, I wouldn't say much about the orders, because that's an issue before Judge Kimaru.
Yes, ma'am.
You raised the question of procedural fairness.
Yes, ma'am.
And sitting as I do here, can I say there was no procedural fairness before at least I hear what they are saying about it? Wouldn't it be better if we hear them, what they say? Maybe they accorded it. And we look at the procedure, whether it meets the constitutional test. What do you say about 2 days? He asks for 2 days. Mr. Waikwa?
Perhaps on the issue of procedural fairness, my colleague Mr. Waikwa has indicated to the sequence of events. Between 12 and 6, no proceedings could have.
Mr. Harvey, I understand the sequence he has given, but don't you think we should give them a chance to tell us whether within that sequence they accorded him the treatment requires under the Constitution?
Yes, my lord, I agree with you. They indeed require a chance, but that chance should be in respect of the substantive inquiry and whether or not to quash that decision. But in the interim, on a prima facie threshold, it is more likely than not.
No.
The petitioner.
The question I pose is, the issue is whether or not, because on the face of it, Mr. Waikwa said the timelines wouldn't allow that to happen. But for us to say, yes, it couldn't or it did, don't we have to hear him? That between this time, we convened a board, this happened and this happened, so that we get out of this matter.
Yeah, my lord, I agree with you. They need to be heard. But even as we wait to hear them, on our part, we undertook full disclosure and filed a copy of an affidavit from the Director of Immigration.
We will look at it. Let's see what they file, Mr. Harvey. Okay? Let's give them 2 days, let them respond. You'll have an opportunity to see what they have said, compare with what you have.
My lord, with the consultation from my colleagues, it's agreeable to come back on Friday for the substantive hearing of the petition itself, the application itself. We will also come with authorities so that we can settle the issue once and for all. My lord, my colleague and classmate asked for 2 days. If anything arises out of what was filed, then I could file my affidavit on the morning of Friday, so that we won't squander the date of
Thursday is which date?
15.
15th. So I've heard you, the arguments for the petitioner. I've also heard Mr. Ntinda. What I gather is that this application is on whether the respondents were right in reporting the applicant, the petitioner, and also declaring him as a person, an unwanted person in this country. Yet he is said to be a citizen of the country. And there is also a second question whether in doing so the respondents accorded the petitioner a fair hearing as required by the Constitution. For the court to make any orders, I think it is important to hear the respondents, albeit briefly, on why they did what they did and whether it complied with articles of the Constitution. I am therefore of the view that 2 days requested by Mr. Matinda are not too many to grant. And consequently, I make these orders. Number one, the respondents do file and serve a response to the petition as well as motion, and file the same on or before close of business on 15th of February 2018. The petitioners will then file and serve a supplementary affidavit if need be by midday, 16th of February, not midday, by 11 a.m., 16th of February 2018. This application will be heard substantively on 16th of February 2018 at 12 p.m. Any other orders?
No, Mary says you are much obliged. Permit me to say two things, Madam. Or we intend to respect your lordship's order, or that I will respectfully insist, and this is really directed to my learned friend Mr. Mutinda, that on that day we should all be prepared to proceed. We shall oppose any attempt to turn this matter in further.
Dr. Haminwa, you are. I just wanted to know if there are any other directions you need from me.
There's another second thing, my lord, I would like to say to your lordship. Permit me to say to you. Would you be kind enough to retain the file in your chambers, not to protect it from the registry?
Why? Why?
My lord, when I come, you are told that the file cannot be trusted.
Have we reached that far?
Well, it happens when I appear in court.
Have we reached that far?
Or it is put in the strong room.
Sorry? This one is urgent. Yes? Yeah, this one is urgent. Mr. Mutinda?
Yes, my lord.
That's perhaps on your side, it's not on the side of the court.
I don't think so. I think it's on their part. We have no intention of disappearing the court.
I'm not suggesting that they are the ones who would do it. Something can go wrong in the registry. But the matter is, of course, something important.
But if it can go wrong, then it can go wrong in my chambers. And they will say I'm keeping the file. No, let's just agree. Is there potential here so that we can take it up administratively?
Could you make that in order that the file could be kept in the strong room?
There is no potential. We will give you file papers. I'm sure it's a public document. And all records in that registry, they are secure. Some which are even more sensitive. But I'm not saying that all matters are important and all of them are secure by the registry. So there's really no alarm.
I wouldn't say what action we will take and let it disappear first. Then we will see what action we will take. Mr. Mutinda? So those are the orders. 11 a.m., 5 p.m., 11 a.m. the following day.
Thank you so much.
Thank you. This file. Hold on to this file. I'll tell you what to hold it.
A motion application urging the judge to make orders so that he can suspend the deportation. Orders are quite many. They include the Honorable Attorney General, they include the Cabinet Secretary, they include the Inspector General, they include the Director of Immigration, they include the Kenya Human Rights Commission. Those are the responses I can think of.
Maybe lastly, before we get to Council Harvey, you did mention about the file being kept in the chambers as opposed to the registry. Mm-hmm. You have fears that perhaps the file will disappear?
No, it's not so. The file is not that it can disappear. The registry is a very busy place. I may point out to you that when I left university, I worked in a registry. A registry is a very busy place. There are many files. At times, papers may be misplaced, and things may not be able to move forward at all. It's not necessary that someone may actually take the file and do something silly with it. It's just that the file can be misplaced, and very genuinely misplaced. And that's why we're asking that the file could be kept by the judge or be kept in the strong room. Yeah.
Thank you very much.
Thank you very much. Yeah.
Now, the State Attorney who represents the Attorney General and the other 6 respondents against whom Miguna has sought several declarations has indicated that he requires time to respond to a number of issues that we have raised. The first issue that we have raised is that on the fact alone, Miguna is a Kenyan citizen by birth. He was born in Kenya of Kenyan parents, and he's been a Kenyan citizen for the last 56 years. Now, there is the second question as to whether, on account of him acquiring a Canadian passport, he loses his citizenship, because that is the argument that was relied upon by Fred Pent, the so-called deportation order by Fred Machani.
Lastly, the yellow ribbon, is the NSK still in solidarity with Miguna at this point?
The yellow ribbon is not peculiar to Miguna. The yellow ribbon is a manifestation by the members of the Law Society that they find profound umbrage as against the executive in its continued habit of disobeying court order and going against the rule of law. Because these transgressions by the state are not just limited to court orders. There are many other instances where the state has abrogated fundamental rights and freedom of Kenyans. And now we will don these ribbons for as long as it takes, until such a time as the executive realizes that the rule of law is that which governs a democratic country. Obedience of court orders is an unqualified obligation of everybody, including the highest ranking official in government.
The march on Thursday, is it still on?
Yes, the march on Thursday is on. We'll congregate here at the Milimani Law Courts. We will agree on a procession, and thereafter we'll march down Kenyatta Avenue to the Supreme Court building with the expectation that we'll be able to meet this Chief Justice and give him our petition as regards this continued behavior on the part of the executive not obeying court orders. Thereafter, if we will have the opportunity, we'll also want to submit a petition to the Inspector General of Police, Mr. Joseph Boynet, and indicate to him that much as it is his responsibility to maintain law and order, it is also his duty to obey court orders and ensure that the rule of law is maintained.
Thank you very much.
Thanks a lot.